Good morning, everybody. It's another HR Matters webinar, and this time we're partnering with Elevation Recruitment, and I'll ask Michelle to tell you a little bit more about Elevation and what they do in a minute. This morning we're focusing our webinar on preparing for IR35. My name is Tom Draper. I'm a Director and Head of Employment in the Sheffield office of Freet, and I'm joined, this morning by Toby Pochron, who will be a familiar face to many of you. He's a managing associate in my team. And I'm also delighted to say that we're joined by Alex from the tax team as well. We chose IR35 because this is one of the topics that our clients are talking to us about. Many of you will be aware there are some changes coming up in April. And we will be looking in more detail at those changes and what it means for your business. The idea of this webinar is not only will you know a little bit more about the changes in the law, but we also want to give you some really good practical tips to take away for your business and help your business to manage these changes. So let's have a look at the overview of this morning's session. First of all, we're going to look at the legislative context, the scope of IR35, what the 6th of April changes are and what they mean for your business, the tax risks and any practical considerations, and then Toby and I will look at the employment law issues that are created by these IR35 changes, the risks of getting it wrong, and then some practical tips. And as Tom said in the introduction, there is a Q&A function on this webinar, so if any questions occur to you as we're going along, pop them in the Q&A box and we will get to answering them during the Q&A session at the end. So before we hand over to Alex, I'm just going to ask Michelle to talk to you a little bit more about Elevation and what Elevation do and how they can help.
Thanks, Tom. So morning, everybody. Just wanted to thank everybody for coming today. And obviously, we're working in partnership with Freet. I know some of you have worked with Elevation in the past, either as a client or a candidate. But for those of you who haven't, I'm Michelle Ferguson. I'm an Associate Director for Elevation and look after and specialise in our HR division. But as a business, we do have 7 specialist divisions. So obviously, we've got HR, finance, engineering, marketing, business support, and our executive search and selection as well. Just as a kind of a bit of an update, we've traded really well and continue to trade well over the pandemic, and we've now got over 35 consultants that specialise in those 7 different areas, and they're all headed up by a lead who's got over 10 years experience in that area. So if you do wish to speak to anyone at Elevation for any of the recruitment advice, whether you're looking to recruit or you're looking to move on with your career, then please feel free to give anybody a shout, or if you want to message us at the end or anything like that, then please do. But I'll pass you over to Alex now. Thank you.
Thank you, Michelle. Good morning, everyone, and thank you for joining. In my segment, I will talk about
Apologies, we just lost Alex there for a second there.
You just on mute, Alex.
Apologies, everyone. My internet just dropped. Can you hear me well, Tom? Am I back on?
We can hear you back in now. Thanks, Alex.
Right. So as I was saying, in my segment, I'll talk about how IR35 works, the changes that are coming, and the risks for employers. Before I go into the detail, I'd like to spend a minute or two just to provide some legislative background. I think this is important because with a lot of clients, I've realized that IR35 has become synonymous with employment taxes in general. And as you'll see, that's not the case. So IR35 is a specific set of anti-avoidance rules. So to illustrate the point, if we look at this slide, that's split between direct employment and indirect employment. So when you're engaging with individuals personally, what you need to look at is whether they will be viewed as employees for tax purposes. And to do that, you apply a series of case law tests. So these are tests that have been developed by the courts over the years. When you're engaging with individuals indirectly, so for example, either via an agency, an intermediary, or say a personal service company, then depending on the facts, you've got a different set of rules applying. So the three main sets of rules are the agency rules, what's called the MSC or Managed Service Companies rules, and the IR35 regime. So today we'll be looking at the IR35 regime, and that is the set of anti-avoidance that deals with a client engaging with contractors via their own intermediaries. So the reason I'm making this point is, if you realize that IR35 doesn't apply for whatever reason, it doesn't mean that there's no employment tax risk. It just means that you need to look at all the other rules. Obviously, we've highlighted this area of law because it's changing. So could I have the next slide, please? So as I said earlier, IR35 is a set of anti-avoidance rules that was introduced in order to tax employees who disguise themselves as self-employed and are working through an intermediary entity. So when I say intermediary, that could be their own service company, or it could be a partnership, or it could even be another individual. But for the purposes of this seminar, I'll just use a personal service company as an example, because this is the most common example that I've come across in practice. So in order to understand why the rules were introduced, I think it'll be helpful to look at the typical arrangement. So how people would try and avoid employment taxes. So imagine you're an employer and you've got an employee who has always been an employee, and they've been working in the same way that an employee would be working. What employers used to do was they would enter into an arrangement where, instead of having an employment contract with that worker, the worker who set up a personal service company, the client will enter into a service agreement with the personal service company, and they pay that company for services. And the result of that was that the company will pay dividends to the worker, thereby avoiding employers' NI. And also, in some circumstances, they could, for example, not take the money out as dividends and just leave them in, reinvest them or whatever. The point is that under this arrangement, less employment taxes would have been paid if you would pay less tax under this arrangement than you otherwise would if you were employed directly. So the reason these rules were introduced was to combat this. So this is how they work. The rules say that if you've got an arrangement whereby you've got a contract between a client and a worker's intermediary, for example, a personal service company, and that worker is working for the client personally in circumstances where otherwise they would have been an employee of the company, then IR35 operates to tax that worker the same amount of tax that they would have been taxed had there not been an intermediary in place. So if we look at the diagram in the slide, where IR35 applies, any money paid from the client to the personal service company would be subject to the same taxes or to the same amount of tax that there would have been had the worker been employed directly with the client. Another aspect of this is that where you've got office holders, so if say you've got a director who's working through a personal service company, The rules also say that to the extent that the director provides services that relate to the duties of a director, then automatically IR35 deems that payment for those services as the worker's employment income. So I suppose the next question following on from that is, how can you tell whether that worker is working in circumstances where they would have otherwise been an employee? So could I have the next slide, please? So in order to determine whether a person is employed for tax purposes, generally there are 4 main tests. So the first one is what's called business on their own accord. So this is quite a wide test, but the intention of this is that if a worker is solely responsible for the success or failure of an enterprise and bear all the risk, then surely they won't be employed. So, for example, if the client operates a project and if the project fails, then the worker stands to lose a significant amount of money for one reason or another, then that's the sort of risk that could show that that worker is in business on their own rather than as an employee. So the next main test is what's called control, supervision, and direction. The idea of this is that if usually in an employment relationship, you can control what your employees do. So if you can show that you cannot control what your contractors do, then you can show that they're not employed. So that's the reasoning. So to illustrate the point, for example, there was a case last year about an ITV presenter. So the Lorraine Kelly case is a good example of this. So ITV used to engage with her as a consultant through her personal service company. And Hmrc tried to argue that, well, she would have been, she was working in circumstances where she would have been an employee had there been a direct contract. But because she could show that she was not controlled by ITV, Hmrc failed in their appeal. So the reason she could show that she was not controlled was, amongst other matters, that she could control the way she performed. She could decide, for example, the running order of the programs and so on. So that's the sort of thing you'd be looking at. You'd be looking at control with regards to how the work is performed. The only caveat to this is when you've got highly skilled jobs. So, surgeons, for example, can, they can be employed, but you're not going to control what they do because it's a highly skilled job. So as with any of these tests, you have to apply it to the facts, and not all of them will be relevant in each case. The next main test is what's called personal service. So employees usually have to, well, not usually, they always have to perform their services personally. So I'm employed by Freeze, for example. I can't send, I can't send another lawyer to do my job for me. I have to provide the services personally. So, and this is a reason why in a lot of self-employment contracts, you would find what's called the right of substitution, where basically the contract says that the consultant can, or the contractor can send a replacement if they wish. However, in order for this to break the employment relationship for tax purposes, it needs to be exercised in practice and it needs to be unfettered. So the client shouldn't be able to say no to a substitute. The last main factor is what's called a mutuality of obligation. So the idea of this is that if a client doesn't have to provide work to a person, and if that person doesn't have to accept the work, then it can be said that there's an employment relationship, because when you've got an employment relationship, your employer is obliged to give you work and you have to do it. So the problem with this is that Hmrc take a really strict interpretation of this test. So in recent guidance, they've said that provided that there's a contract in place and that some work was performed, then that's that degree of mutuality is sufficient to satisfy this test. There has been cases where this has proven to be wrong. However, in practice, this is a very difficult factor to rely on when it comes to employment status determinations for tax purposes. In addition to the main tests, there are a number of other tests, which I'm not going to go into because we've not got enough time. But just to illustrate the point, this have to do with equipment provided by the workers. So for example, if a particular job can only be done if you've got really expensive, significant equipment and the worker provides that, then that could, in some cases, show that that worker is not employed. Other factors can include having a number of clients or the length of engagement. Sometimes IP can sway the determination one way or another. So if there's intellectual property developed as part of a project and the client keeps it, that can show sometimes that there's an employment relationship in place, because that's usually what happens to when employees create intellectual property. I think that's enough on this subject. So could we move on to the next slide? So before I go into the changes that are coming in, I think it's important to understand what the position is currently. So first of all, there's two IR35 regimes. We've got the general regime and the off-payroll IR35 regime. At the moment, the general IR35 regime applies to the private sector generally. So when that regime applies, the intermediary, so for example, the personal service company, is responsible for paying any additional tax and for compliance. Whereas if the off-payroll IR35 regime applies, it is the end client that has the responsibility to pay the taxes. And currently, the off-payroll IR35 regime only applies to public authorities. So could we move on to the next slide? So from next month, the general IR35 regime will only apply to small companies. Small companies for this purpose are companies that have a turnover of less than 10.2 million a year, balance sheet assets of less than 5.1 million, and less than 50 employees. So when the general IR35 regime applies, the intermediary is responsible for compliance and must pay the additional tax. So in that arrangement that we went through in the first slide, or the second slide rather, if the IR35 general regime applies, it is the worker's personal service company that would be responsible for the additional tax. Now, the off-payroll IR35 regime that's coming in from 6 April will only apply to medium or large private companies and local authorities. Now, medium and large companies are just those that are not small. So you just apply the tests the other way around. So they have to have a turnover of more than 10.2 million, balance sheet assets of more than 5.1 million, and employees and more than 50 employees. So these are three financial tests. So if 2 out of the 3 are satisfied, then a company will be medium or large. So when this new regime applies, it is the client that will be responsible for compliance. So if you're a medium or large company and you've got loads of contractors, it will be your responsibility to determine whether the rules have been complied with. In addition to that, the client will be responsible for issuing what's called a status determination statement. So this is a statement that says that we've undertaken a review of our engagements with contractors, and we've determined whether the IR35 regime applies or whether it doesn't. And you have to give this statement to both the worker and the entity you're contracting with. The other nuance that these new rules introduced was that it is the fee payer that must pay any additional tax. Now, the fee payer is not always going to be the client. So could we have the next slide, please? So as an employer, if you're engaging with a contractor's personal service company, you're always going to be the fee payer because there's no more people down the chain. However, when you've got someone like an employment agency down the chain, so in the example that you can see in this slide, you might have, as a client, you might engage with an employment agency, and the agency might engage with someone's personal service company, and that personal service company will provide the worker. So in that diagram there, usually the fee payer and the person who would have to pay the additional taxes if IR35 applies would be the person paying the personal service company, so the agency. However, if the client has not complied with their obligations, for example, they've not issued a status determination statement, or they've not put in place the necessary disagreement process, then that liability goes back to the client. So this is one of the reasons that it's important to comply with the new rules, because it effectively shifts the liability. It can shift the liability from one party to another. So could we move on to the next slide? So risks for employers. So as discussed, there's two regimes. We've got the general IR35 regime and the off-payroll IR35 regime. With the general regime, we mentioned that if it applies, it's the personal service company's responsibility to pay the additional tax. However, that doesn't mean that there's no risk for the employer. Employers need to consider whether they could be seen to be facilitating tax evasion, which is a corporate offence. So if as an employer you know that the regime applies and you know that your contractors' personal service companies are not complying with the rules, then as an employer you could be liable for facilitating tax evasion. And also you've got the general reputational and commercial damage that comes with that. When the off-payroll IR35 regime applies, so if an employer is a medium or large company or a public authority, then the risk is that the additional tax that is due where this regime applies will be payable by the employer. So if you've got arrangements that fall foul of the rules for, say, 3 or 4 years, then there's a risk that Hmrc might come after you for all of those payments in one assessment. So the other risk, I suppose, is that when you're engaging with other parties, so for example, with another agency that provides the worker, then if you don't, as discussed earlier, if you don't follow the procedural compliance rules, then that POA liability can come back to you, regardless of the fact that it's the agency that's paying the intermediary. obviously you still got the reputational and commercial damage risk that will occur if Hmrc raise an investigation. Can we move on to the last slide, please? So a few practical considerations. So if you're a small company, so the general IR35 regime applies, then you would obviously need to identify which contractors operate through intermediaries, as you would anyway, but also identify whether you've got any office holders that are employed via their intermediaries. So, for example, directors or any person who holds an office in the company. And obviously you should perform your reviews in the normal way. So review the relationships and establish whether IR35 applies and what steps you would need to take. When if as an employer you're a medium or large company or a public authority, and therefore the off-payroll IR35 regime applies, then the practical considerations would be similar. So again, you need to identify your contractors who work through intermediaries and any office holders. But also, in addition to undertaking a review, you should of course make sure that you issue the relevant status determination statements, set up a disagreement process, and tell your contractors what they can do if they disagree with your determination, and consider any other options that might be appropriate for you in terms of engaging with those contractors. So for example, putting them on payroll or any other commercial solutions. I think that's all from me. So I'm going to hand over to Toby, and do send your questions at the end of the seminar if you have them.
Marvellous, thank you very much, Alex. So yes, my name's Toby. I am going to be looking at this more from an employment law perspective. So we've been through all the facts and circumstances to go through for tax legislation. You'll be glad to hear, obviously, that employment law doesn't make this any easier, because the tests for employee and worker and self-employed individual are different under employment law perspective than they are under the tax perspective. Right, so I'm going to look today at the three categories of individual that we have in the labour market at the moment: employees, self-employed contractors, and then workers. Right, the most common form of engaging between a company and an individual is that of an employer and an employee. Now, you'd think that for employment law, deciding whether or not someone is an employee or not would be the most simple question, but it's probably one of the most complicated, right? And under the legislation, what we have is a definition from the Employment Rights Act that defines that an employee is, and I'm going to quote this, an individual who has entered into or works under, or where the employment has ceased, worked under a contract of employment. And it's just entirely unhelpful, because what you have here is a position where technically under the law, if you work under a contract of employment, then you're an employee. But what if there is no contract of employment? And what if that contract of employment is completely different to the reality of that situation? So what we then stuck with doing as employment lawyers and as business people as well, is looking then at key factors from case law that define whether or not someone is or is not an employee. And what that produces is possibly my favorite legal term, and it is the irreducible minimum. Now, the irreducible minimum is a three-stage test that decides whether or not somebody is or is not an employee. If you've got these three things, then you're likely to be an employee. If you do not have these three things, you have two or one, whichever one it is, you don't have all three, you're not an employee, right? So the irreducible minimum itself is personal service. You're an employee, you got to do your work personally. No right, no ability, cannot substitute in any way, right? You've also got the mutuality of obligation. Right? That's an obligation on the employer to provide work to the individual, and the obligation on that individual not only to do that work, but to be available to accept that work as and when it is offered. right? And then control. Control itself on an employee is possibly one of the most important factors. You know, it is the actual or contractual right to have someone be told exactly what to do. So an employee can expect to be told their place of work, their days and hours of work, have a day-to-day direction over how they perform their work, have policies, procedures, practices all put in place that monitor the way in which that work is performed and the standards to which they should have that work done. Now, that's the starter. The starter is the irreducible minimum. Do those three exist? But then what the tribunal look at is all the other circumstances that go along with how that individual trades with that other person, with that business. You know, how they're paid, what rights they enjoy, how they're integrated into the employer's business. There are loads. There are loads that you have to go through to meet those tests. But we always start with the irreducible minimum. So that's always one to check out. You know, control, mutuality, and whether or not there is a requirement for personal service. So the other status that we then have is a contrasting view of self-employed contractors. So a self-employed person is in business on their own account. They have a financial stake in the success or failure of that business. And a relationship can be defined as someone who is that of a client or customer nature. And usually relates to a specific piece of work. Right? Those who are self-employed have little to no employment law rights. They have little to no protections certainly under employment law anyway, and they have to pay their own taxes as they're not going to be paid through PAYE. Now, just because an individual is an employee or self-employed for tax purposes does not necessarily mean that they're an employee for employment law purposes. And as I say, you know, the tests are broadly similar, but there is a difference of interpretation. And there's a heavy emphasis within the employment tribunal, certainly at the moment, of finding people to be either employed or workers. So an example of this is the Mutuality of Obligation test that Alex talked about. So Hmrc's interpretation is that mutuality is satisfied as long as individual is paid for doing work. Now, that's not the case in employment law. What employment law looks at is there an obligation for that employer to offer that work and an obligation on that individual to perform that work that is offered. Now that in and of itself, that's not clear. It's not as if that part of the test is anything that you can really particularly hang your hat on, because it's so difficult to understand, but it's all about what the intention of the parties were at the time. So looking back and saying, is there a requirement? Is there an obvious obligation that we will pass work to that person? And will they always do it? Yes. Did that happen in practice? Yes. And there's probably going to be that obligation there. Now, if that's not complicated enough, you know, there is then this separate category of worker. So worker is actually just on the next slide. So you can pick me over to the next one. That'd be wonderful. So worker is this sort of this halfway house between the two. You know, what the law recognises really is that someone might not be able to meet all the tests, so the irreducible minimum to be an employee, but equally they can't really be described as a self-employed individual. They're somewhere kind of in the middle, right? So what we have is this definition from the Employment Rights Act. Which again specifies out that a worker can be someone who works under a contract of employment, or it's someone who works within, and this is quoted on the screen, any other contract, express or implied, so it's just all about the reality of the situation, where that person individually undertakes to do that work personally for another party to a contract, and whose status is not that of a client or customer, right? So we have these two limbs to that worker test. You've got the A limb, which is just a person being a normal employee, as you would normally expect, and then a B limb. And that's the second category of worker, and that's where you have possibly one of the most areas for challenge certainly within the UK legislative regime. And it's looking then at that person who's sort of in the mix there about whether or not they can do their work personally. Do they have to accept that work? Are they subject to that overarching control as well? But what I can really hear throughout this presentation is, why does it matter? Why does it matter for the employment law aspects of this, what status that person has? So I'll answer that question on my next slide. And here it is, it's the significance of employment status. So we have this great table here that specifies out the different rights that each of these categories of individual has. You have the employee there, and obviously this is done to show the mass set of rights that employees have. If you want to be better protected as an individual, you become an employee. You've got rights to health and safety, national minimum wage, rights to notice, right to not be unfairly dismissed, you've got statutory redundancy pay. You're gilded with these set of rights. Workers are somewhere in the middle. They have the right to be paid the national minimum wage, bring a whistleblowing or discrimination claims, not to have their pay deducted from them when it's a statutory amount of pay that they should be receiving, right to pension, right to time off for dependents. But what they don't have is other statutory leave. They don't have rights to notice. They don't have rights to request flexible working, the way in which they perform their role, and there is no protection for them for unfair dismissal at all. So there's that obvious de-stripping of rights, but it says, well, look, these people are doing work more flexibly. They're not in control as much as a normal employee would be. And then we have the self-employed people, and they're at the end here with a single tick that shows that they have the right to have a safe workplace provided to them. But from that emphasis, you can see all the rest of those rights just reduce. And that's why it's so attractive for businesses to think, well, actually, if I have a self-employed person working for me, I can dismiss them, I can get rid of their services, I don't have any of these other obvious ongoing rights that I have. Treating them as definitely self-employed would certainly be better for the business. It might be better for that individual as well, because they're able to trade more flexibly than they would otherwise do, especially if they were an employee, when they would have to be performing services at set times as provided by that business. So that's my summary of those significance for those rights. And I'm going to click you over to Tom. He'll take you through the next part of the seminar.
Fantastic. Thank you, Toby. And thank you, Alex, as well. I thought that was a really, really engaging presentation. And thank you for taking us through all the changes to IR35 that are coming up. Toby's talked to you a little bit about the different types of issues that can be created in relation to employment law, and particularly in relation to the category of worker, which doesn't really exist in tax law, but obviously has a lot of significance in employment law. So just picking up on that, what are the risks of getting it wrong? Well, as we've seen, the tests for whether someone is employed by Hmrc are quite similar to the tests that the employment tribunals use as well. And so if you're going through the process that Alex talked about evaluating your IR35 contractors and working out whether or not those people that you engage through intermediaries are likely to be employed from a tax point of view, then they're also likely to be employed from an employment law point of view, or at the very least, workers. So what are your options in terms of what you can do if you think that you're inadvertently engaging workers or employees as contractors at the moment? Well, you could stop using them as contractors altogether. You could provide them with a status determination statement telling them they're within the IR35 regime and therefore bring them onto your PAYE payroll. Or you could look at changing your operating model, reducing the risks and changing the way that you engage with them, reducing the level of control, personal service and mutuality of obligation that Toby and Alex have talked about. Or you could change your operating model in another way by using potentially an umbrella company or something like that. All these potential options could still leave you with employment law risks in the employment tribunal. If you convert someone to PAYE, they might start questioning why this didn't happen sooner. And it could actually alert them to the fact that they've been engaged on the face of it as a self-employed contractor, when the reality of the situation is that they were a worker or an employee. And as Toby pointed out on the last slide, that means that they could have had a lot of rights that they've been denied. So for workers, the two big potential claims in terms of finance are claims for backdated holiday pay and auto-enrolment pension breaches. In the employment tribunal, as a worker, you can claim up to 2 years worth of backdated holiday pay. And if you replicate that across dozens or even hundreds of contractors in your business, then that's a huge potential risk in terms of those workers taking their claim to the employment tribunal and saying, actually, I want to be paid for all that holiday I was prevented from taking. And so it's worth having a look at this in detail to see whether it applies to your organisation. At the moment, Hmrc are saying that they won't pursue businesses for backdated tax. That's not the case with the backdated holiday pay. Although obviously the difference here is that the workers themselves would have to go to the employment tribunal, stick their hand up and say, I want a judge to look at whether or not I've been a worker for the last 2 years and I've been denied access to holiday pay and I want to be reimbursed for that. The difference here is obviously Hmrc can look at this independently without the permission of either the business or the workers and contractors involved. But obviously, if you're going to face employment tribunal claims, they need to be started by the workers. If you take one of the other options that I talked about, perhaps the first option of stopping using the contractors altogether, if those contractors were in fact employees, then by terminating that relationship, you may inadvertently be dismissing that employee. And if that employee has got more than 2 years service, then that's likely to be an unfair dismissal because you won't have the potentially fair reason and you won't have followed a fair process. And so that also creates a legal liability. And again, if you multiply that across the contractors, you could have multiple claims for unfair dismissal on your hands. And employees can claim up to 52 weeks pay for unfair dismissal if they aren't able to get another job within that period of time that's going to reduce that loss. So there are very clear employment law risks here in terms of the risks of claim, sorry. So even if you are successful in defending one of these claims, that can still be a costly process. The starting point in the employment tribunal is that each party bears their own costs. And so even if you win, you're very unlikely to be able to get the costs of defending the claim paid by the employee or worker who's bringing the claim against you. And then there's the added reputational risk. Employment status issues are high on the media's agenda right now, and we'll have a look at the Uber case that came out of the Supreme Court recently, but that's just one example of the focus that's on what people call the gig economy and issues that arise out of employers engaging people on the face of it on a self-employed basis when that isn't actually the case in reality. So there is added reputational risk as well. And then you have businesses whose whole model is built on using contractors in this way. And here, obviously, the risk is increased very significantly because if you get one employment tribunal decision against you that says, well, actually, I think this contractor was in fact a worker or an employee, then if you're engaging contractors on that basis across your workforce, then those other contractors could easily get wind of this and they could take that decision in relation to one worker and they could use that as a precedent to bring their own employment tribunal claims. And I imagine that there'll be claimant law firms waiting to jump on this if they start to see employment tribunal decisions go against employers. Then you could easily find that other claims are brought on the back of that. So there are some real employment law risks for us to mitigate against. And just a word on the Uber case recently, you might well have seen some coverage about this in the press. This wasn't an IR35 case, so the Uber drivers that brought the claim don't provide their services through an intermediary business. They work on their own account. But the key thing here was that the Supreme Court said that the starting point is not the written contract. And they made an analogy about contracting out of the national minimum wage rules, which is unlawful. And they said that is exactly what Uber were trying to do with the contracts that they created with the drivers. Those contracts didn't have any relation to what was going on the ground with these people. And previously, before this Supreme Court case, lawyers and businesses thought that they could at least start off by creating a lovely, beautiful employment, a lovely, beautiful self-employed contract that would be the starting point that a judge would look at when deciding employment status. And even if it didn't really represent actually the reality of what was going on the ground, it would at least put you on the front foot as an employer. Well, the Supreme Court case in the Supreme Court in Uber said, well, no, that we're not even going to look at the contract. We're going to look at the relationship on the ground, and then we're going to look at the contract to see if the two tie in with one another. And so you can see that that actually creates a difficulty here for IR35 as well, because if businesses are engaging with IR35 contractors and they've gone to the trouble of putting a written contract in place, then if it ever comes before an employment judge, the judge isn't going to start by looking at that contract. They're going to start by looking at the type of test that Toby and Alex have been talking about: mutuality of obligation, control, personal service, and how integrated that person is within the business, and all the other factors that we've discussed. And it's only then that the judge is going to look at the written contract to see if that actually accurately reflects what's going on. So I'm just going to finish off by looking at some practical tips on the next slide. I've talked a lot about contracts there in the light of the Uber case, but it doesn't stop clear contractual terms being important. But following the Uber case, what is important is that those clear contractual terms are accurate. They reflect the relationship between the parties. Having a written contract is still very important, because it can provide clarity to both parties. Good contracts can be used to guide the behaviour of both the contractor and the hirer. So the key is putting a clear contract in place and then following it. So as long as you do that, you're starting off with your contractors on the right foot. So that's the first practical tip, and I've got 7 of these. I wanted to either have 5 or 10, but they're too important to take any of them out, and I didn't want to add 3 in just for the sake of it. So we're left with 7. The first one is to have clear contractual terms in place, and then regularly review those contractual terms. The second point is to identify who your IR35 contractors are. Not all businesses will know who they engage through intermediary companies. So find out, make a list. That's my second point. The third point is review each contractor based on the employment status tests that Alex has talked about. There is an online tool that Hmrc have produced. It's called the CEST tool, Check Employment Status tool. And you can have a look at that, and there are multiple questions that you can put into that tool that will give you an indicative idea about whether or not someone falls within the IR35 regime or not. The fourth tip is keep reviewing employment status over time. Relationships change. Contractors could easily become employees or workers over time as a result of the changes in the employment relationship. So keep it under review. If you've engaged someone for over 2 years as a contractor, remember that increases the risk slightly if that person is actually an employee, because of that unfair dismissal risk I talked about earlier. The fifth practical tip is place a status determination regime in place. Alex talked about the changes to the IR35 rules, meaning that as clients, we need to provide status determinations to our contractors. Make sure that you do that. Make sure that there's a right of appeal built into that status determination policy, because it's a legal requirement after April. The sixth tip, look at other self-employed relationships. We've been focusing on IR35 on this webinar, but that doesn't mean that engaging contractors directly or in another way means that there's no employment status risk. There isn't an immediate need to look at those people because there isn't the change of the law that we've got with IR35, but that risk is still potentially there if you're engaging someone on the face of it in a self-employed relationship when actually the reality points to that person being an employee or a worker. There's still risk there from an employment law perspective. And the final tip here is, this is really tricky stuff. Get some advice if you're struggling with it. If you think that there is a danger that some of your contractors are employees, do talk to us. We are here to help. We're very pleased to have Alex and the tax team advise us on the intricacies of the tax law points here. And Toby and I are obviously here and available to talk to you about employment law implications as well. So that's the webinar. Thank you so much for listening to all of us. We're going to move on to the Q&A function. And I think, Tom, are you going to take us through the questions that people have been asking while we've been talking?
Yeah, that's right. So thanks very much, everyone, for your contribution. Thank you very much for your questions. If you've got any more, please send them in. The first question we've got is, how does using umbrella companies differ from using one's own limited company for interim assignments?
Right, so these are fundamentally different arrangements. So someone's personal service company is usually a company which they either own wholly or with a couple of other associates. So when someone is engaged by the personal service company, obviously IR35 applies in the way we described earlier. The idea of umbrella companies is that the worker doesn't have a stake in the umbrella company. Instead, they are employed directly by them. I would mention, however, that there's different types of umbrella companies. So there are also what are called managed service company providers. So a different arrangement that you might have is when, say, for example, a contractor signs up to an arrangement like that, and they usually put them in a vehicle together with loads of other people. So it could be an LLP or another company. So the worker doesn't have a material stake in the company. However, they still provide the services through it. And what that applies, usually a different set of rules applies rather than IR35, which is the MSC rules. I mean, as Tom briefly mentioned, when you get into that sort of arrangement, it's quite complex, so do get advice. The line gets really blurred as to whether IR35 or another set of rules applies when you're engaging with complex intermediaries like that.
Yeah, thanks very much. So does this also include national insurance as well as tax? If so, yeah.
Oh, sorry, go on. Yeah, what was that the question?
If so, it's also correct that the employer pays ERS national insurance even if the person is self-employed contractor.
Yeah, but that's the point. That so IR35 it basically recharacterizes that person as an employee, so they're not a self-employed contractor, regardless of what they claim to be. So the effect of IR35 is to trigger a tax charge that is broadly equivalent to what you would have if they were employed. And if they were employed, you'd have income tax and all the NIs. I mean, technically speaking, you can even raise a slightly bigger tax charge, but that's a bit too complex to get into now.
Perfect. This is probably for all of you. So, what are some examples of work that you've currently done under IR35?
Do you want me to? Right, I'll start from a tax perspective and then hand over to Tom and Toby. So from my perspective, I usually get two types of work. So I'm either going to review a particular arrangement for a contractor, and usually this will be a senior manager. So they'll get paid a lot, so they want to make sure that they don't fall foul of the rules. Or I might be asked to look at a set of arrangements for a number of contractors. So if an employer has, 10, 20, 1,000 contractors, but they all work on broadly the same facts, I could do a review based on those facts. And the structure of the work that I usually provide is to review those facts, give an opinion as to whether the anti-avoidance applies, and then recommendations as to what the employer can do to mitigate the risk. And of course, we will then change the contracts if necessary. I'll hand over to Tom and Toby, but from an employment perspective.
Yeah, I mean, in terms of that, I mean, we work together on this, don't we, Alex? So when Alex did his initial review, we then talk to the client about what the employment law risks are and how to mitigate against those. And they fall into broadly two categories. Some advice and support about putting in the status determination regime and the appeal mechanism. And then secondly, how to change the relationship so that you are either deciding to engage that person as an employee and putting in all the documentation and procedures that you need to do that, and how to speak to the employee about why you're doing that, or how to change the relationship so it is a genuinely self-employed relationship, and reducing the employment law risk for things like backdated holiday pay and unfair dismissal in the process.
Thank you. Is an office holder a statutory director, someone with the title director, or will an office holder also include managerial level?
So I think this is one for me again. So it doesn't just include statutory directors. So an office for these purposes is, and it is a position with a certain degree of permanence. So it would include, managing directors. Basically, broadly speaking, if there's a position in the company with a title and a set of duties and someone occupies it, that's an office. It's so a test you can apply is, I suppose, is to consider whether had that person not been there, would his position still exist? It's not a bulletproof test, but it'll give you an idea as to whether you need to look into it.
Perfect, thank you. Conscious of time, so we'll probably have a couple more questions, and then if we've not answered them, what we can do is follow up directly following the webinar. So can Hmrc make claims prior to April 2021 in the private sector?
Yeah, I mean, I assume that's to do with IR35 claims. So whether they can, but it depends but not necessarily against the employer. So as Tom mentioned, when the off-payroll, with regards to the off-payroll regime, Hmrc said that they would not do so. And I suppose that gives you a degree of comfort. If the general regime applies, they will be going after the personal service company or the intermediary. But again, Hmrc have given some informal assurances, so you do have a degree of comfort. I mean, by law, Hmrc can, when it comes to the general IR35 regime, which has been in place for a long, long time, they can go back for usually 4 years, or if you've been careless, 6 years, or if you've been fraudulent, up to 21 years. But again, these are rare examples, and Hmrc have said that that they won't necessarily pursue claims that arose as part of the introduction of the new rules. Also important to mention what Tom mentioned earlier, that that promise, if you will, is to do with IR35. So, you know, if you're engaging with loads of contractors and you've been treating them as self-employed, whereas you should have been treating them as employed, and there's no intermediary in place, then nothing really changed. So technically, yeah, they can still make claims prior to April, because it's not an IR35 issue, it's just a general employment tax issue.
Perfect. So finally, would charities class as a private company for the purpose of IR35?
Yeah, they can be called by IR35, yeah, in the same way.
Okay. Perfect. Thank you very much. So that's it for the end of the webinar. If we've not had a chance to answer your questions, what we'll do is we'll follow up directly following. The recording and the slides will be shared later on in the week as well. Finally, thank you to Tom, Toby and Alex for today's discussion. Thank you for Elevation Recruitment, and thank you for attending.